This is a caution plus 3 interview being tape recorded. I am PC Jamie Pickard, 771 Lima Tray attached to Stratton Police Station. The other officer present is
PC Stanton, 617 LX from Stratton Police Station.
We are in the interview room at Brixton Police Station, and I am interviewing
Brunella Longo, flat 622 Harpenden Road, SE 270AE.
There is no other person present. The date is the 16th of April 2015, and the time is 10:14 AM. This interview is being tape recorded and it may be given evidence if your case is brought to trial. At the conclusion of the interview, I will give you a note explaining what will happen to the tapes. I must remind you that you have the right to free and independent legal advice. You can speak to a solicitor in private any time of day or night, and this legal advice is free. You can speak to a solicitor in person. If you do not want to speak to a solicitor in person, you can speak on the telephone. If you do want legal advice, or you want your solicitor present, if the interview can be made unless certain exceptions apply. Do you want to speak to a solicitor, or do you want them present at the interview?
No, I think it's not necessary at the moment.
Are you quite sure that you don't want to speak to a solicitor in person or on the telephone?
No, not at the moment.
Okay. At this time, you are under caution, so you do not have to say anything, but you may harm your defence if you do not mention when questioned something which you later on in court. Anything you do say may be given evidence. Do you understand the caution? Do you need me to explain it to yourself?
Well, if you want to define the status, that would be brilliant. Yeah.
It's caution plus 3 interview as mentioned, so you are free to go, you're not under arrest, and you are able to have free and legal independent advice. You're here to answer some questions and answers. Under caution, it basically means that if this is brought to trial from any point, you answer questions that put to you there that will put to you that you have not answered, then you can't rely that on in court, and there might be an inference. There might be an inference by court.
Upon them, yeah.
Okay. Okay, so you understood, perfect. Okay, Miss Longo, you're here today because there's been an allegation that you've criminally damaged the locks of your flat number 6, 22 Harpenden Road, after you've been evicted by your landlord, Mr. Gilbert. Date of which?
The 11th
of March 2015. Yes. Thank you. In relation to that, do you want to tell me what happened?
Well, what happened was that I called the Metropolitan Police around, I think it was 8:30 PM. I've got this also reference number of my call, that was CAD9386, because I found myself in a appallingly astonishing situation of being locked out of the flat with my dog locked in, and before changing the keys and called the locksmith, I asked myself if there was anything else I could do, and the first thought was to call the police and ask them, because I had relied all day long on the how can I say, sensible reasoning of this person, alleged landlord. And I say alleged landlord because this is now under confiscation proceedings by the council, because he didn't respect an enforcement notice, and there is a litigation he had been on since long with the London Borough of London. And he was convinced that he had the right to evict me on papers made up, if I may say so, because, what can we say, mistakes made by court officers. And I also called the employees at the county court in order for him to be reassured that there was something wrong going on. So he was convinced he had the right to evict me. He had not. And in spite of this conversation we had during the day, he decided to change the keys, and, as I said, lock myself out and the dog in. So you asked me, the officer who answered the phone call asked me, but there is a possession order, there is a tenants agreement. I explained the situation. The situation is that I rented this flat in 2012 from a letting agent. I paid 6 months in advance because of a number of reasons, and I was in a hurry to enter a flat. I checked with the land registry. He was the landlord, because I had a previous experience terrifying about an alleged landlord not being the landlord. So I reassured myself with the fact that he had a title register for this flat. I trusted the letting agent, and I started the tenancy. The tenancy, after 6 months, entered into difficult period because the landlord got a receivership. I'm not sure if this is the right receivership on a fixed charge. Basically, what happened that on the 27th of March 2013, I passed the landlord details to the insolvency service because I was declared bankrupt in 2013 because of a previous property lawsuit. And under Perjury Act, I had to pass all these details. This happened on the 27th of March. On the 2nd of April, so a few days later, the landlord told me that he had to go. He wrote me, with immediate effect, agents have been appointed for the future collection of rent. And these were appointed receivers, Tony Howe and Kevin Osher, care of Davis Brown Chartered Surveyors.
So receivership
started in April 2013.
And that was agents brought in to collect
the
rent from you.
Exactly. So in 2013 we had this 6 months of receivership from these appointed receivers on a fixed charge. That ended in 2013 in September. In September, on the 25th of September, and that was after the expiration of the assurance shoulder tenant agreement that expired the 23rd of September 2013. After that date, Gilbert Garrick on the 25th of September wrote me a letter saying, I'm pleased to inform you that from the 21st of September all rents should be paid into Mr. Garrick account, which is stated below. And the appointed receivers confirmed here, please be advised that as of Tuesday, the 23rd of September, Tony Howe and Kevin Usher have resigned as fixed church receivers. So basically, Mr. Garrick came back into ownership and receivership of his rent. From that point on, the rent was paid direct to him. What happened was that during the 6 months of receivership, I had discussed with the surveyors some defects of the property, and I also became aware that there was an enforcement notice on this converted house that Mr. Garrick had not respected, and also received from the council planning enforcement officer some questionnaires, letters to provide feedback about the situation of the property and things like this. So I basically searched the planning permission database. I discovered this. I discovered the house was attemptedly on sale, on auctions, on a number of occasions, and other issues that are not pertaining to this matter. And I started to discuss with him the situation, also because we have a practical problem, two practical problems. One is the bin collections, the refusals, and because they're overcrowded property, 6 flats in a converted house, there is no space for bin, and bins are not even sufficient, and blah blah blah. Secondly, we have a letterbox that is outside the house. That means that it's not safe at all for us to have confidential correspondence, because it may be easily accessed by everybody, because it's external. And there is a lot of correspondence coming in for non-existing tenants. He went upset and he said, I start a repossession claim. And he did, but using the wrong notice. He required possession after the expiration of the short-order tenants agreement. When I had become a statutory tenant, blah blah blah, he sought possession with the wrong form of the notice. So this, to cut it shortly, this claim failed, and after a number of attempts to mess up all the proceedings, the district judge Simmons clearly said in September that the first order he had got from a deputy district judge was dismissed, and the warrant for eviction discharged. I also asked the court to say a word in respect of the deposit, because he had refused to provide evidence. He had reprotected the deposit once the assurance sort of tenant agreement had expired. So,
just to clarify one point.
Yeah.
So, with a short hold tenancy agreement, when did that actually cease? When did that stop or expire?
The assurance short tenant agreement was for 1 year.
Yeah.
And was since the 24th of September 2012 until the 23rd of September 2013. On the 25th of September 2013, the landlord said, please pay me blah 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 in this way. Yeah. And he basically acknowledged that I had entered a statutory tenancy, and he should have served from that point on other papers that had.
Have you been paying rents to him in this time?
Always by standing order.
Yeah, and that's been accepted with no issue. So he's accepted the rent from you since
Absolutely, absolutely.
Are you still currently paying rent? Has that still been accepted?
He has decided on the 11th. Yeah. He wrote me, I have the text message with me, he doesn't want to receive any rent at all. Okay. And I assume that that is because he should be liable with the rent tribunal as well, because of other reasons. So he's accepting rent on a property for which he has a confiscation proceeding going on. I think so.
And the deposit you initially paid when you first took out the agreement, is that still being held by him?
Yes.
How much is that?
Is, I think, £870.
870.
Yeah. Oh, let me check. I have it for you. Do you need that precisely?
No, I think I've got it actually.
Because I think I have the papers with me as well.
Mr. Garrick provided me with some papers as well in relation to your tenancy agreement and such. And I can see here that you've got a deposit of £870.
870, yeah.
And that's just to confirm that hasn't been released back to you. That is still being held by you.
No.
So, and how much is your rent a month?
£870.
870. Okay. How many times has Mr. Sorry.
Garrick.
Yes. How many times has Mr. Garrick petitioned for eviction in relation to us?
Just once.
Just once.
In fact, I told him this claim failed.
Yeah.
So if you want to repossess the flat, I think first of all you have to show your cards, because it seems quite clear that you are trying to exploit myself. And secondly, you should start a new claim.
Yeah.
You should start a new claim, and well, this is not something that came from me. It came from Mr. Wilford, that is the planning enforcement officer from the council. Yes, I spoke with Mr. Wilford. Mr. Wilford told me in a very animated conversation in which he tried to convince me that I had to go because they want to repossess this house. They want to, be in charge of the house. And Mr. Wilford told me at a certain point that Mr. Garrick is not serious in this possession, that is instrumental. And I said, yes, it is, but it's not my fault. And you cannot say me, a private tenant, that I have to go without possession proceedings, and so on and so forth. And also, I informed also the housing register, because what what happened, that the council, obviously, when I was served by Mr. Garrick this notice, even if I immediately brought back to him, look, this is invalid, I learned this thing because of my property lawsuit, the one that brought me to bankruptcy. I learned these things. So I immediately told him this is invalid. But for my own safety, I immediately went to the council and said, look, in terms of prevention of homelessness, please consider that I'm in this situation. But also I kept informed the housing department of the council that this claim was invalid. So I said, yes, you bring me my name on the housing register list, but consider that as long as I'm the private tenant, this is my only home.
Yeah. Okay, I understand everything that you've said. From what I've got from the investigation, that you've been invited in for a caution +3 to determine whether criminal damage has occurred or not. So I understand this is all civil when you've gone to the council and all of this stuff is kind of civil, and I understand you're dealing with that. So if we can just ask you some questions about what's happened with the locks and the criminal damage.
Oh yes, sure.
And then we'll go from there. Is that okay?
Yeah, absolutely.
Perfect.
Sorry.
That's fine.
Stop me if I start speaking
I understand
a lot.
that there's a lot.
Yes,
It's
sorry.
okay.
Stop him because it's immensely.
It's okay. I understand there's a lot to it. I understand.
I understand that there's a lot to it. From play well, but I understand there's quite a history. So just go back to the locks on the day. What time did you weren't there for the initial eviction when they arrived? What time did you return?
No. I'm sorry. What you asked me?
What time did you return to the property?
Oh, I return at about, I think, 8:30.
And you discovered the locks had been changed, is that correct?
Of course, yeah.
Was there a notice put on your door at all by anyone?
Oh yes, he put a piece of paper, I think is somewhere here. He put a piece of paper, say owner, warning. Yeah, he put this.
Okay, have a look. I've been passed by this by Brunella. A handwritten note by Gilbert Garrett, the owner, saying this flat has been repossessed and any unauthorised entry is forbidden, will represent a criminal offence. Signed, Gilbert Garrett, owner, 7th March 2015. And this was taped to your front door.
It was in the front door with the dog inside.
I was going to just go on for that. Okay, thank you. So all your property, including your dog, live living pet, had been left locked inside and you didn't have access to that.
No, and I immediately called him.
And when was the last time you fed and watered your dog that day?
Oh, the dog has the food and water always with her because she's used to stay up to 12 hours without me in the flat. So she always have water and plenty of food. So she's a small pet.
So you mentioned that you called police first under CAD number CAD number 9386 of the 11th of March 2015.
Exactly.
You spoke to police, you explained the situation to them, that you've been right home, you've been evicted, and you're potentially holding, you're paying rent and such. And is it correct in saying that they advised you to get the clocks changed, or was it the police and the other advised?
Yeah. They say that you have the right to enter the flat.
You have the right to
consider this contest that there is no valid possession order. It was dismissed. That there is no new claim. You have the tenants agreement. You have the statutory.
You have the
law.
And you then called up a locksmith. Have they come out and then changed locks for you?
Yes.
And that was at a cost of £190.
£190 because they told me that was a scissors lock or sort of. I can't remember exactly the name. Anyway, very expensive. Yeah. And luckily enough, I had the money to change the lock. It was quite a long job, and I was able to enter the flat. I think it was about 11:30. I first informed all the 6 flats, the tenants, because the people, vulnerable people living there, and they might have been, scared of this thing. I didn't know what would happen. So before calling the police, I informed the tenants on this job.
At any point did you contact Mr. Garrett?
Yes, I phoned him before doing the job.
So you phoned him?
Yes, because I said, I phoned him and say, look, I also had a chat, and I had it then in writing confirmation by this employee at the county court. They confirmed that they made some errors in the transmission of documents between a court and another court. So basically, he was messed up in some point, and he was confused in some point because of the claim for the return of the deposit still going on with this job, with a circuit charge. So basically, he had a hearing in which he was, I wouldn't say deceived, but at least he was led to believe that he had the right to evict me, and he was not. So I phoned him, and I said to him, look, I'm changing the keys. Are you really sure you want me to do this?
And what did Mr. Garrett say?
He says, you are a trespasser or sort of. You have no right to do that. And I say, well, I'll do it because I have to enter my flat. That's it.
You had to enter the flat for your dog's sake and for your retrieve on property.
Sorry, say again.
You had to enter, and the reason you entered your flat was to safeguard your dog and your to your property. Is that correct? A lot have been changed. You're now still currently residing there. Is that correct?
Yes.
Has Mr. Garrett been in contact with you since in relation to blocks?
He sent a message the day after, saying something like a justification for having done that. He wrote something like, you were not there, so I fed the dog. That is absolutely not true at all. I said, let me check because I kept it.
So my understanding is that you believe there was no legal basis behind the eviction happening on your level, due to the fact that you've got a handwritten note put on by Gilbert Garrett, and from all correspondence you received by the court, the warrant hadn't been reissued, that had been formally dismissed by district judges in law. Is that correct?
Exactly.
So you did not believe that this had been a legal eviction?
No,
at all. Okay. You got any questions in relation to criminal damage? No, mine aren't covered. So
there are some other issues that we just never going to overwhelm you with particulars that are not containing this point.
The reason that Jamie's asked you to come in today is just to clarify what's happened in terms of criminal damage, because someone's made an allegation that you caused criminal damage on the lock. So whatever else has happened, then if that's civilian and stuff, we will just need to establish what's happened with the locks, and then we'll go from there.
At this time, in relation to criminal damage, I don't have any further questions. I'm going to conclude, unless you have anything to say in relation to criminal damage. Is there anything else you'd like to wish to add at this time?
Well, the week after, Mr. Garrick, I don't know if it's in relation with the criminal damage or not, but he told me that I had no right, because we met in front of the house, and my bike had been damaged 4 times in the last month before this event, and up to the point that I had to change it because it was completely destroyed, apparently by very white children living at flat 2. And basically, he told me that I had no right to park the bike in the backyard.
Okay.
I had the key of the door that gives access to the backyard.
Yep.
And have been parking my bike there since I did. And so that is another episode of, I would say, harassment, because I don't have an understanding of any other. I bought another bike, and in order to avoid, political confrontation and other issues, I'm simply carrying the new bike in this light. I have to pick this one up.
Sure.
Yeah.
Okay. Thank you for that.
It's an exercise, extra exercise. I don't need, actually.
I'll provide you Form 987 in relation to what's going to happen with the tape for the
Yes.
tapes or discs, as they're called. This interview is concluded at 10:40 a.m. on the 16th of April 2020.